I drove 4 brutal hours up mountain roads to my grandfather's cabin, and the first thing that greeted me was a chain link fence, 6 spike strips buried across my drive, and the HOA president standing on my porch with a cold beer and a smug grin. He pointed at a typed notice like it was gospel and said, "This ain't your land anymore." I nodded, turned my truck around, and drove off slow, because I knew the fight that night would be stupid without a map. My name is Garrett. That cabin belonged to my grandfather, Eldon Marsh, who bought those 2 1/3 acres back in 1961 because he needed a place to breathe, not as an investment, not as a backdrop for someone else's brochure. He built a 1-room cabin by hand, hauling cinder blocks up a logging road in a truck that shouldn't have made the climb. And the place smelled like pine and stale coffee and every honest thing he ever did. My father added a room in '87. I put in a decent well pump in 2019, and for decades that little spot sat like a quiet punctuation at the edge of a development that later got named Ridgeline Estates. Sterling Briggs moved into the big house on the ridge in 2018, and by 2020 he had the gavel HOA president, unopposed, smug mid-50s ex-middle management with a taste for policing other people's porches. He used words like aesthetics and property values, the way some men use a hammer on everything and without nuance. The first notice about my cabin was a joke. The second was a fine. The third had a photo circled in red like it was homework he needed to grade. Then a surveyor showed up. Then the fence. When my rear tires hissed that night and I heard rubber give out under my truck, I sat there and let the anger stand tall for 5 minutes. Then I called my cousin Vaughn, paralegal in Asheville, who said, "Don't argue, document, then bury him." It sounded mean until I understood the wisdom. I grabbed a spare, patched the tire the best I could, then came back with Colt, my brother-in-law, who runs a contracting business and carries a total station like other men carry a Bible. We walked every marker iron pin, Eldon's oak, the concrete monument by the road, and Colt's instrument laughed at Sterling's fence. It crossed the boundary diagonally 14.3 feet at the deepest point. The spike strips were anchored in my gravel. This was no petty HOA spat. This was trespass conversion and property damage waiting to be documented. We took photos, timestamps, field notes. I did not cut the fence. I was not trying to be noble, I was trying to win. That is Act 1. The gut punch, the steel, the padlock, the humiliation on my own land, everything a story needs to make your pulse quicken and your breath shallow. Over the next 48 hours, we assembled a case like we were building a slow, stubborn machine. Philippa, a property lawyer Colt referred me to, read the survey, looked at the photos, and said bluntly, "He filed a piece of paper with the HOA, not a deed. That's his first mistake." She saw the trespass, the conversion, the damage claim for my tires, and best of all, she saw how a little paperwork could topple a big bluff. Then came the thing I didn't see coming: Wendell's binder. Wendell's the kind of neighbor who keeps notebooks and a memory like a Ledger 71 retired electrician patient as an old clock. He sat me at his kitchen table with coffee and a slow fan, opened a 3-ring binder, and pointed at the original plat and CC and RS pulled from the county recorder. He said quietly, "Your parcel wasn't part of Ridgeline Estates." It sounded like a small sentence until I realized it meant everything. My grandfather's 2 1/3 acres were a pre-existing parcel adjacent to the development, never included in the subdivision plat, never legally subject to the HOA covenants. I had been paying dues for 6 years on land that legally wasn't theirs to govern. That discovery turned Sterling's fence from enforcement into theft. And Section 14.3 of the CC and Rs, the clause about removing board members who file false claims, became a loaded gun sitting on the table. So we split the work into tracks. Philippa filed a temporary restraining order for trespass and conversion and attached the survey and photos and emergency motion that a judge could hear fast if the documentation was clean. Wendell and Darlene, another neighbor who knows every corner of the mailbox gossip network, began quietly collecting signatures for a removal vote under Section 14.3. I called a local reporter who'd covered HOA overreach before. Orrin agreed to come. I called the property management company and asked them to explain why they'd transmitted a baseless adverse claim, and I filed a complaint with the NC Real Estate Commission. Little things kept aligning. Act 2 was the counterpunch neighbors who remembered documents that didn't lie procedure that cut the other way. Darlene photographed the empty community notice board 32 times over 3 days to prove Sterling had failed to post the emergency meeting as the bylaws required. That absence of notice made any votes taken that night procedurally vulnerable. The TTRO put a court order between Sterling and his spike strips. Wendell's petition gathered more than the two-thirds required. The management company looked nervous. The story was no longer just my grievance. It was a pattern. Sterling panicked in his own way. He called allies, tried to spin the TTRO as a personal civil squabble, filed a county building complaint about my cabin, which of course had permits from 1987, and the propane hookup was permitted in 2019, and tried to keep the meeting going. He introduced last-minute fines and an emergency enforcement motion aimed at my parcel. The meeting he expected to control turned into a packed room, 40 people instead of a dozen, because when you start scaring neighbors, they show up. At the meeting, I put the TTRO on the table like a small, obvious thing, bright white paper that landed with a precise little sound. Wendell stood and presented the petition with signatures. Philippa on speakerphone walked everyone through the procedural law. Sterling barked that, "This is my association," and for the first time, he had more mouth than authority to back it up. He adjourned the meeting, stormed out, and drove back up the road toward my cabin as if he intended to finish the job himself. We called the sheriff. A deputy arrived, found Sterling at the fence with bolt cutters in his hand, and served him the TTRO. He stepped back from the padlock while Colt's truck lights cut through the Blue Ridge dark, picking out those black spike strips lying in my gravel like proof of a petty war. Orrin took a photograph that ran in the paper the next day, the fence, the spike strips, the deputy Sterling in the background with the bolt cutters at his side. The visual was clear. A man who'd tried to privatize power was now standing exposed in public. That is Act 3, the resolution, not savage revenge but consequence. The spike strips came up under sheriff supervision, each one photographed and bagged as evidence. Blue Ridge Community Services cut ties with the HOA account. A membership vote removed Sterling under Section 14.3 by 31-2. An audit found misdirected assessments and elders got refunds. My civil case settled months later, covering legal fees, tire replacement, and enough to winterize the cabin properly. Sterling lost his house within 8 months as lenders accelerated foreclosure, a cascade kicked off in part by public scrutiny. He moved out on a Tuesday. Darlene said she didn't feel glad about the man losing a home. She felt glad the power was no longer being abused. That distinction matters. I want to be plain about two things. First, I don't celebrate someone's ruinous sport. I don't enjoy the part where a person loses a home. Second, the lesson isn't law always wins. The lesson is that paperwork and neighbors and quiet persistence win more often than bravado. Eldon's cabin survived because there were iron pins in the ground, because permits had been kept, because a retired electrician kept a binder, because a lawyer knew the legal levers, and because ordinary people showed up and documented the truth. If you care about a place, a porch, an acre, a tree line where your family breathed, treat your records like they are part of the property. Pull plats from the county recorder, save permits. Keep surveys in a real folder and find the neighbor with notebooks. Quiet people with paper are terrifying to bullies. The best weapon is the boring one: timestamps, witnesses, surveys, and a lawyer who knows how to use them. The ending that sticks with me is small and satisfying. 6 spike strips lifted from my driveway one by one, photographed, bagged, and filed. Neighbors standing on Eldon's porch at dusk, laughing, not mean laughter, but the kind of relief that sounds like rain after a long dry spell. My kid helped re-chink the old mortar last fall and said between swings of a trowel, "I get why you fought for this." That was the victory, not the headlines, not the settlement, but the way a place stays a place. I'll leave you with something to argue about when someone in a small community uses private power to harm neighbors. And the remedy is legal, public, and humiliating. Is that justice, or is it revenge dressed in paperwork? Tell me what you think below, and if you've ever had an HOA or an official. Try to take something that was yours, drop your story. Share, argue, and if you have a binder, a plat, or a permit, Keep it close because quiet people with documents are the scariest thing a bully can face.